Good morning to all honorable justices and judges present today. Honorable Deputy Minister of the Department of Justice and Constitutional Development, Andri Snell, representatives of all schools participating in the National Schools Moot Court Program of 2024, Deputy Dean of the Law Faculty of the University of Pretoria, Professor Charles Maimela, Commissioner Professor Tepo Madingozi of the South African Human Rights Commission, all commissioners and other dignitaries present here today, the CEO of the South African Human Rights Commission, Mr. Mkhize, learners, educators, parents, representatives of the Department of Education, the Department of Justice and Constitutional Development, and the Center for Human Rights at the University of Pretoria, and all officials of the National Schools Moot Court Program. My name is Advocate Crystal Pillay. I'm the Chief Operations Officer at the South African Human Rights Commission, and I have the privilege of directing the program for today. I welcome you all to the 2024 National Schools Moot Court Competition, final round. I would like to congratulate all the participants who have succeeded to the final round, and we're looking forward to listening to your legal arguments and to your debates with our honorable justices and judges today. To start our proceedings this morning, we will sing the national anthem, followed by the recital of the preamble to our Constitution. Can I please ask us all to rise for the singing of the national anthem? I'd like to call on Samkelo Zondi. She will be leading us in the recital of the preamble to our Constitution.
Preamble of the Constitution of South Africa. We, the people of South Africa, recognize the injustices of our past. Honor those who suffered for justice and freedom in our land. Respect those who have worked to build and develop our country.
Respect those who have worked to build and develop our country.
And believe that South Africa belongs to all who live in it.
And believe that South Africa belongs to all who live in it.
United in our diversity.
United in our diversity.
We therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the Republic.
Adopt this Constitution as the supreme law of the Republic.
So as to heal the divisions of the past. And establish a society based on democratic values. Social justice and fundamental human rights.
Lay the foundations for a democratic and open society. In which government is based on the will of the people. And every citizen is equally protected by law. Improve the quality of life of all citizens. And free the potential of each person. And build a united and democratic South Africa. Able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Nkosi sikeleli Afrika. Morena boloka setjhaba sa heso. God sensate Africa. God bless South Africa. Modimo fatshetsa Africa. Hosi katekisa Africa.
Thank you all. You may be seated. I will now call on the court bailiff to introduce the panel of judges to us.
Introduce Chief Justice Matopo for the day, sitting in the middle. I have the pleasure of introducing our core judges for the day, Justice Mutali, Justice Mali, Justice Linyai, Justice Tulare, Justice Slingers, Justice Rashid Umo, Justice Kase, Justice Tolme, Justice Mia, Justice Richie, Justice Mila, Justice Kwibana, and Justice Patel.
Thank you very much. I would just like to acknowledge that our citation of the Constitution was recited by both Ms. Zondi Samkelo and Leshabela Sandra. I'm now going to move on to our program. I would now like to call Professor Commissioner Madlingozi of the South African Human Rights Commission to provide us with a welcome to the 2024 National School Moot Court Competition Final Round.
Good morning to you all on this beautiful Sunday. I want to recognize our presiding officer, Justice Mutopo, fellow judges and justices, Deputy Minister Nell, thank you for joining us this morning. DG of the Department of Justice, DDG Said, Mr. Linda Botman from the Department of Basic Education, together with Ms. Malebu, our CEO from the Human Rights Commission. Thank you so much. My job is simply to welcome you. I know the learners are very nervous and eager to go, so I won't waste much time. I was given 5 minutes. I will only take 3 minutes. First of all, I want to thank the Department of Justice and Constitutional Development, as well as the Department of Basic Education. We appreciate this collaboration. It has been 13 years, started with the department, with the Center for Human Rights. This year, the relationship has been easy. It shows that we've been in this game for a long time. The problem that we chose for this year is a problem to do with the right to education. It has to do with norms and standards. It's as if we're prophetic when we came up with this problem. I also want to thank the Office of the Chief Justice, together with the Chief Justice, for organizing the venue, this venue for us, for organizing the judges. And we really want to thank justices and justices and our Commissioner Kwinana for joining us this morning. To the learners, all of you participated in the past 6 months. All of you are winners. I don't mean it as a cliche. I mean it truly that you are winners. You've put yourself out there. You've competed. But more than that, I hope that you've made a lot of friendship. The aim of this competition, of course, is to instill constitutional values in the students. It is to cultivate constitutional literacy. But most importantly, we hope with this competition to contribute as a free institution to the next generation of social justice warriors and human rights lawyers. I stand before you as one of the beneficiaries of the Moot Court. The first time I took part in the Moot Court was ages and ages ago. I did not have confidence. I did not come from a good school, but I was able to be chosen to compete in an all-Africa Moot Court, where we did very well, and it really gave me confidence. So when we say that the Moot Court can really change the trajectory of your life, we really mean that, and I'm, a testament to that. So without wasting much time, on behalf of the Department of Basic Education, the Department of Constitutional Development, Department of Justice and Constitutional Development, I declare the 13th National Schools Moot Court open. Good luck and thank you.
Thank you very much, Commissioner Madlingozi, for that very warm welcome this morning. I would now like to call upon our Deputy Minister of Justice and Constitutional Development, Mr. Andries Nel, who will be providing us with the address this morning. I know in terms of the program, we were meant to receive a message of support from the Deputy Dean, but I'm told that the Deputy Dean has not joined us as yet. So, Deputy Minister, please come through. Thank you.
Chief Justice Matopo and all honorable judges here present. I rise to be representing Government of the Republic and the Department of Justice and Constitutional Development in particular. Let me just say that it's a great honor for me to appear before this court. Today, I can just say to the participants that this is the best chance that I will also have of ever appearing before the Constitutional Court. I think your chances of appearing again are much better than mine, and therefore I've grabbed it with both hands. But it is indeed a very deep honor and privilege to be here. I think maybe just by way of background to say that I've walked a long road with the Moot Court many years ago during my first life as Deputy Minister of Justice and Constitutional Development. I was approached by the sadly now late Professor Christoph Heinz of the University of Pretoria Center for Human Rights Studies with the concept of this Moot Court. And he requested me to facilitate an engagement with the then Deputy Minister of Basic Education, Minister Enver Surti. And I think through those engagements, the Moot Court got underway. And I must say, it's really grown from strength to strength. So that as we meet here today, you are not only appearing before a full bench of 11, but in fact you're appearing before an overfull bench of 14. And I think that just bears testimony to the seriousness with which both the judiciary, the executive, our Chapter 9 institutions, and the legal profession take this very important event. I think we'd also just like to acknowledge and to thank the South African Human Rights Commission, its commissioners represented here today by Professor Tsepo Madlingozi, also the University of Pretoria's Law Faculty, in which Professor Maimela has played a very important role. I think we'd like to thank the organizing team from the Departments of Justice and Constitutional Development, Basic Education, and the Human Rights Commission, members of academia, the court, the learners in this auditorium and across the country who are watching this live stream in support of their teams, their families, and fellow South Africans across the country. Last but not least, I would be very remiss if I didn't acknowledge my instructing attorney, the Director General of the Department of Justice, and the entire Justice team. As I said, this is my first appearance at this Moot Court in my reincarnation in this position, but it's certainly not the first contact that I've had with it. And I think it's particularly significant that this Moot Court takes place at this significant moment in the history of our country where we celebrate 30 years of freedom and democracy. I think it's particularly significant for you as the learners in 2024 to be participating in this event during this very momentous year, and that it will contribute towards building and defending our very hard-won democracy. It also makes us hopeful knowing that some of you will be leading us both in government and also assessing where we are in the next 30 years. So it's very important that all of you, both the teams and those of you here in the gallery, consider yourselves as champions of human rights and democracy, and that you lead by example. And I think therefore this program becomes even more relevant in terms of instilling and educating young people, and through them also their parents, their family members, and broader society on constitutional values, human rights, and active citizenry. Human rights awareness and constitutional literacy is vital as it contributes to a society that treats each other with respect, is tolerant of all cultures, behavior, gender, race, age, ethnicity, amongst others, and is a society where everyone feels that they belong. On Friday, I was at Freedom Park, and I hope that next year, as part of your itinerary, it would also include a visit to Freedom Park. We raised that because it touched us very, very deeply to be at Freedom Park on Friday to welcome back the remains of many of our heroes and heroines who were forced to leave our country, to live, to work, to struggle in exile, and sadly paid the ultimate price. I think just underscoring the fact that our freedom was not for free. It came at a very, very high price. And I'm sure that those who have returned to their land are resting very peacefully now, knowing that the baton has been passed to those of you who are here. But I think of particular concern is that that struggle is not over, because the legacy of our past is in many ways, sadly, still with us, both in the attitudes of some of our citizens as well as the material conditions under which many of us still live. And I think that's the subject also of the cases that you will be arguing here today. But the racism that still plagues some of our schools is shocking. To hear learners using the K word to refer to each other, commenting on hair texture, auctioning learners is not only incomprehensible, but is contrary to the values of the Constitution, for whom so many lost their lives. We urge you to be champions of building a culture of human rights and root out this evil behavior by standing up and standing together against discrimination and promoting tolerance. You have it in you, and we anticipate and hope that this experience has made you realize that each one of us is responsible for sustaining and building this democracy, as you are the agents of change, as you've demonstrated in participating in these moot court competitions. We also want to take this opportunity to call upon caregivers and educators to incorporate support programs of belonging in all schools so that we can continue to excel as a nation. The last time South Africa won the international competition, and we have confidence that you can raise our flag again this year as proud South Africans for our constitutional democracy and for the future of our youth. We were advised that on 3 occasions the winning teams have gone on to represent South Africa internationally and have won the international moot court competition, the last time being in 2021. So we already wish you well in anticipation. The Constitution and one of the constitutional pieces of legislation, the Promotion of Equality and Prevention of Discrimination Act, the PUDA, or the Equality Act, as I'm sure you have come into contact with in your preparations for these finals, is core to our constitutional value system. And it's upon the centrality of equality and the right to dignity and worth, fairness, equity, and social justice. It's also the backdrop of the legal question that you will be advocating before this court today. We have every confidence that even if you do not choose law, you will serve as ambassadors of promoting the Constitution and its values. We'd also like to encourage you to encourage more learners to participate in this program so that even more learners will benefit from this opportunity. We hope to see some of you, DG, We hope to see some of you in a few years working for the Department of Justice as attorneys in the various offices of the State Attorney, as state law advisors, as drafters of our laws, as formulators of our policies, as prosecutors, and as other legal professions within the department. Law firms, legal educators, counsels, and lawyers across the country join us to expand this competition and come forward to mentor some of the teams where possible and expand the ability of learners in the Moot Court competition to defend and advocate for human rights and uphold the constitutional values. Chief Justice, the other Chief Justice, even though she is not at this event, but I'm very, very sure that she is also watching on the live stream together with parents, families, and learners across the country. We're grateful for your leadership and recognizing the value of moot courts. We're advised that the first annual National Moot Court competition took place here at the Constitutional Court. We're not advised, we know that from personal experience, on Human Rights Day, the 21st of March 2011. We have here today judges from various divisions of our high courts, including the Constitutional Court itself and the Supreme Court of Appeal. As we said earlier, this is the first time that we not only have a full bench of 11, but an overfull bench of 14. And therefore, we would like to express our appreciation to all of the judges who've availed themselves, who've traveled from all over the country, and we know that for some of them the traveling was not that smooth, for giving up their weekends. Your presence really, really is highly, highly appreciated, and it's a testament also to your ongoing commitment to making justice accessible, to demystify this institution, and to act as very, very important role models to these potential lawyers. So legal practitioners, senior law students, government officials who mentor the learners and also sat as adjudicators at the provincial and preliminary rounds, support staff, members of academia, you've all contributed towards the success of this event. We would also like to thank members of the media for giving ample coverage to this event. And with that, I think just to say that I think this year's theme of access to technology is a topic that was very, very well chosen, both from the perspective of highlighting how technology has the potential not only to promote access and equality, but unfortunately how unequal access to technology can reinforce the divisions that exist in our society. I say that at the risk and not without wanting to preempt any of the arguments. But I think with the rise of other technologies like artificial intelligence, this issue will become even more burning. Some time ago, I read a very interesting article about developments at the University of Johannesburg, where they have developed a virtual courtroom. They're also exploring technologies that, in essence, create virtual lawyers. So I think those are all developments that have a lot of potential, but they also have potentially huge ramifications for the profession and the legal system. I'm not going to give an outline of the case. I think counsel are more than well equipped to do that, but just to say that I think it is a very relevant one, and I must say that I'm looking very much forward to hearing your arguments, and I'm very, very, very thankful that I'm not sitting up there and being in the difficult position of having to judge. With that, Chief Justice, I thank you very much for the honor of my first and last appearance before the Constitutional Court.
Thank you very much, Deputy Minister Nell, for your insightful address and also for highlighting the significance of the National Schools Moot Court competition and its long-term impact on the lives of our learners and on society at large, including this extensive collaborative effort with the Moot Court, Schools Moot Court Partnership. It is now a privilege for me to hand over to the Chief Justice presiding over the Moot Court today. That is Justice Matopo. I wish the participants good luck. You made it thus far, and I know that you will be giving it your best shot. So good luck. I will now hand over to the bailiff.
And Uhuru High School versus the Minister of Education. The court is now in session. You may be seated.
For the applicant, who's appearing for the applicant? Firstly, introduce yourself, your name, your surname, and who you are representing, and then press there in the middle so that we could all hear you. Can you just press? Just press there. You will be given 5 minutes to give a brief outline of your case without any interruption in terms of questions from the members of the bench. Your 5 minutes starts now.
May it please the court, your honorable justices. I am Offenza Masanga and I'm here with my co-counsel Milani Sese as we appear on behalf of the applicant. Both my co-counsel and I will only consume 9 minutes of our time as we will utilize the remaining 2 minutes for rebuttals. If it pleases the court to justice, counsel of the applicant will provide a factual background on the case that brought us all here today. Azania Mazibuko is a 17-year-old learner at Uhuru High School in Umlazi Township in KwaZulu-Natal, and it was during a science fair that Azania discovered that another public school in the same province, which is Alpha Secondary School, has a science laboratory, Wi-Fi, and computer rooms. Azania felt a deep sense of unfairness at this unequal access to technology, and she therefore went to consider it with a public interest called Education for All. Education for All, alongside Azania, decided to lodge a court action against the Department of Education and the Department of Basic Education. The High Court and as well as the Supreme Court found in favor of the respondent, and the matter is therefore now being appealed at the Constitutional Court. As first counsel of the applicant, I will address the court on Section 29 and Section 28 of the Constitution, supporting it with legislation and some case law. My co-counsel will then address the court on Section 9 of the Constitution with legislation and also case law. Your Justice, this case concerns the right of a public school to receive education in a qualitative form, and the obligation of the state to provide the necessary resources to fulfill the enjoyment of this right for the applicant. As the Constitution is the supreme law of the country, which simply means that it is above all laws, as counsel of the applicant, we rely on Section 29, subsection 1A, which states that everyone has the right to a basic education, including adult education. For binding value to this court, as counsel of the applicant, we would like to submit to this honorable court that the right to a basic education in line of section 29, subsection 1A is immediately realizable. For binding value of this court, we rely on the case of governing body of the Juma Masjid Primary School versus Issei Number and others. It was in paragraph 37 of this case where it is declared that it is important to understand the nature of the right to education. This right is immediately realizable, and unlike some of the other socio-economic rights, this right does not require, there is no internal limitation requiring that the right be progressively realized within available resources subject to reasonable legislative measures. The right to education may only be limited in terms of law of general application, which is reasonable and justifiable in a society based on equality, human dignity, and freedom. It is evident that not much was done to realize the right to education at Uhuru High School, because although this school offers science as a subject, the learners at Uhuru High School do not have a science laboratory in order for them to be able to conduct their experiment and scientific researches, even though it is clearly stated in the regulations related to minimum uniform norms and standards for public schools infrastructure in paragraph 14, subsection 1, that all public schools that offer science subjects must have a science laboratory. The legislation, which is the South African Schools Act, also states in section 5, subsection A, which are the norms and standards for basic infrastructure and capacity in public schools, that in respect of the schools, there must be availability of laboratories for science, technology, mathematics, and life sciences, which should all be provided for by the state, which is the respondent. The inadequacy in school infrastructure, including the lack of computers and internet access, was addressed in the case of Education for All versus Minister of Basic Education. In this case, the court recognized the importance of technology in education. Your Justice, nothing is as disheartening as having to witness yet another South African child having to fight before they can fully exercise their rights, after it is clearly stated in the country's very own supreme law, which is the Constitution, in section 28, subsection 2, that a child's best interest is of paramount importance in every matter concerning the child. In this case, Your Justice, the best interest of a child, which is the applicant and as well as her fellow schoolmates at Uhuru High School, is to have access to technology at their school, in order for them to be able to fully enjoy and exercise their right to education at school. And for the binding value of this honorable court, as counsel of the applicant, we rely on international law. We are given authority.
Mrs. Masango.
Yes, Your Justice.
Your 5 minutes is up.
Yes, Your Justice.
And then you can proceed, but expect questions from members of the bench.
Thank you, Justice. We are given authority to rely on international law by section 39, subsection 1B of the Constitution, which states that when interpreting the Bill of Rights, the court must consider international law. Your Justice, this means that the court must consider international law instruments such as the Convention on the Rights of a Child, which is well known as the CRC. In this convention, Article 3, Sub-Article 1 states that in all actions concerning children, whether undertaken by public or private social welfare institutions, the courts of law, administrative authorities, or legislative bodies must know that the best interest of a child shall be a primary consideration. The best interest principle is also included in the ACRWC, specifically in Article 4, Sub-Article 1, where it is clearly stated that the best interest of a child shall not only be a primary consideration, but the primary consideration. It is hence that the applicant submits to the court that by not providing technology at Uhuru High School, the Department of Basic Education and as well as the Department of Education is not considering the best interest of these children as the primary consideration. And as the counsel of the applicant, we therefore submit to this honorable court today that the lack of access to technology does indeed violate the applicant's right to education. And by not providing access to technology at Uhuru High School, according to section 28, subsection 2, the respondent would be contravening against the country's very own supreme law, which is the Constitution, because they are not considering the child's best interest as of paramount importance.
Now, Ms. Masango, if the respondent were to say that the best interest of the child would require that there be a progressive realization of those rights, instead of having those rights immediately afforded or granted? What would you say? In other words, to say, yes, we accept and acknowledge that you need your instruments like your laptop and everything else, but as the respondent, give us time to progressively acquire those instruments so that we can make those instruments available to Uhuru and her school over a period of time. And what would you say to that?
Your Honorable Justices, as I've submitted that the right to basic education is immediately realizable, using the binding case law of the Juma Masjid Primary School, the governing body of Juma Masjid Primary School versus ISO numbers and others, where it is clearly stated that unlike some of the other socio-economic rights, this right is immediately realizable. There is no limitation requiring that the right be progressively realized within reasonable measures subject to legislative measures. The right to education is immediately realizable and the state is obligated to do so, not to take progressive measures.
Thank you, Ms. Masango. I just want to look against the background that many people see injustices and simply walk away. And that in these facts before us, we have Azania taking the matter first to this SRC at the school and then at school level up until here at the court. The fact that she didn't look away amidst a country of people who generally just look away from a problem against the concept of access to justice, is it a factor that we should consider, that this young township girl is asserting a right, a constitutionally guaranteed right according to her? Is it a factor that we should consider? Thank you.
Your Honorable Justice, yes, it is a factor that you should consider this, as I have already stated that the best interest of a child shall be of paramount importance. And according to Section 28, subsection 3, a child is anyone under the age of 18 years. And Azania in this case is a 17-year-old learner, meaning that she falls under the category of children. Therefore, it is binding that the court considers this.
Thank you. Ms. Masangane, I understand that your client is a grade 11 learner. And you referenced us to section 29(1)(a) of the Constitution. How is your client covered in this section as a grade 11 learner?
Your Justice, although compulsory attendance only ends at grade 9, everyone from grade R up to 12 falls under basic education. And in order for us to submit this to the court, we rely on the CAPS document, which was produced by the DBE, which is the Department of Education, and it covers from grade R up to 12, simply meaning that all learners in school, from primary school grade R up to matric level, which is grade 12, falls under basic education.
Thank you so much, Advocate Masango. You will be interested to know that in the recent past, in year 2000, we had a case before this court between the government of the Republic of South Africa and Irene Grootboom, wherein she needed to have a right of access to housing, which this court allowed. The reason why I'm giving you this background is I'm interested in knowing from your side, what impact should the finance or budgeting by the respondent have in your case? Are we simply to order that you have right of access to technology, irrespective of the financial means to achieve this? Or perhaps we need to give some attention to what the Chief Justice indicated, that we may not be ready now, but yes, you are entitled to that right, but you will get it over some time. Any comment on that?
Your Justice, Council of the Applicant is very aware that the state relies on the budget. However, in the South African Schools Act, particularly in the Regulations of Framework Act 2004, it was ensured that the Executive Council must, in accordance with in accordance with limitation of protocol, contemplate everything that is mentioned in the requirements that is needed in order for learners to be able to fully exercise their right to education, meaning that access to technology such as laboratories and connectivity at the school is within the budget of the state when it comes to basic education.
Council, I'd like you please to address the issue of limitations under Section 36 of the Constitution. Is this right able to be limited in terms of Section 36, and how would that affect your argument that this access to technology should be immediately realizable?
Your Honorable Justice, Section 36 of the Constitution clearly states that any right in the Bill of Rights may be limited, however, only in terms of law of general application to an extent which the limitation is reasonable and justifiable. And as counsel of the applicant, we submit that the limitation of the right to education cannot be reasonable and justifiable in accordance to Section 36 of the Constitution. My co-counsel will also elaborate more on that as it is part of her submissions.
My apologies. Council, I was saying, you are saying there's another school in the district enjoying the same right as that is not being enjoyed by the others, the school that Azania goes to. For you, what does that mean in terms of rights? What right, except for the fact that yes, in total, right to education is being violated, but what does that say when one has regard to one school against the other?
Your Justice, this goes hand in hand with Section 9 of the Constitution, which is equality. And it is the applicant's knowledge that all public schools are equal in the eyes of the law, meaning that if another public school can exercise their rights and has access to resources that another school do not have, it constitutes as inequality and discrimination.
Thank you, Council, for the good presentation. Your time is now up. We'll afford your co-counsel the opportunity to address us. You said it's on the Section 36 limitation.
She's going to address the court on Section 9 and Section 10 of the Constitution and briefly on Section 36.
Thank you.
If it pleases the court to justice.
As it pleases the court, your justices, I am Milani Sese, the co-counsel for the applicant, Azania Mazibugo and Education for All. As my co-counsel has already mentioned.
Sorry, can we have your name, please?
Milani Sese, your justices.
Milani who?
Sese, your justices.
Se?
Sese.
Sese, thank you.
Yes, your justices.
Thanks.
If it pleases the court, your justices. As my co-counsel has already mentioned, I will be arguing under the second issue in dispute, which states that the unequal access to technology between public schools violates the learner's right to equality and protection from unfair discrimination. Your justices, the lack of access to technology at Uhuru High School violates the learner's right to equality in terms of Section 9 of the Constitution. Denying learners at Uhuru High School access to technology based on their school's lack of resources constitutes unfair discrimination. This inequality in access to technological resources creates a division between learners from these two schools, leading to inequality and hindering the prospects of those at less privileged institutions. We submit the promotion of equality and prevention of unfair discrimination, which we will hereinafter refer to as the PEPUDA. Section 1 of the PEPUDA defines prohibited grounds of unfair discrimination, which includes not only the listed grounds such as race, gender, and disability, but also in subsection B, any other ground where discrimination based on that other ground causes or perpetuates systemic disadvantage, undermines human dignity, or adversely affects the equal enjoyment of a person's rights and freedoms. In this case, Your Justices, socio-economic status, while not explicitly listed under the PEPUDA, we submit that it does constitute a prohibited ground under the PEPUDA. The inequality in access to technology between Alpha High School and Uhuru High School perpetuates systemic disadvantage and undermines the dignity of learners at Uhuru High School, thereby constituting unfair discrimination. In support to our argument, we submit the case of Social Justice Coalition versus the Minister of Police. The Equality Court recognized that discrimination based on poverty can impact the social and economic rights protected in the Constitution. Your Justices, this aligns with the argument that the inequality faced by learners at Uhuru High School constitutes unfair discrimination based on their socio-economic status. We submit Section 9, subsection 2 of the Constitution, which states that equality includes the full and equal enjoyment of all rights and freedoms. The failure by the Department of Basic Education to provide technology at Uhuru High School violates Section 9, subsection 2 of the Constitution, resulting to learners at Uhuru High School to be unable to fully and equally enjoying their right to basic education compared to learners at Alpha High School. This discrimination undermines the learner's right to human dignity as enshrined in Section 10 of the Constitution. By limiting access to education, which is a fundamental human right, the Department of Basic Education is violating dignity, a non-derogable right, which is also the cornerstone of the Constitution. The right to human dignity is entirely protected. This is also explained in the table of non-derogable rights. We go a step further and submit the Constitutional Court judgment in the case of Huxon versus Lane and others. This Constitutional Court held that discrimination on unlisted grounds can be unconstitutional if it impacts human dignity. We now humbly submit the 4 stages that determines whether Section 9 is being violated as per the case of Huxon versus Lane and others. Firstly, Your Justices, there has to be differentiation treatment. Was the differentiation treatment? If yes, does the differentiation treatment lead to discrimination? If it does lead to discrimination, is the discrimination unfair? Is the discrimination reasonable and justifiable? If the discrimination is unreasonable and unjustifiable, Your Justices, this is unfair discrimination. Therefore, Section 9 of the Constitution is violated. In regards to this case at hand, Your Justices, there is indeed differentiation treatment due to socio-economic status. The differentiation treatment is unreasonable and unjustifiable in terms of Section 36 of the Constitution. We submit the South African Schools Act 84 of 1996, Section 5A, the norms and standards for basic school infrastructure and capacity in public schools. Under subsection 2A, Roman figure 6, it states that in respect of school infrastructure, there must be availability of laboratories for science, technology, mathematics, and life sciences. The mentioned measures are intervention strategies that the Department of Basic Education should employ in order to address the lack of access to technology at Uhuru High School. In conclusion, Your Justices, this inequality puts learners from less privileged institutions at a significant disadvantage that hinders their ability to receive quality education. Learners at Uhuru High School are now... Yes, Your Justice.
If I may.
Your Justices, this inequality puts learners from less privileged institutions at a significant disadvantage that hinders their ability to receive quality education. Learners at Uhuru High School are now unable to fully and equally enjoy their right to education, further limiting their educational opportunities. Now, if it pleases the court, your justices, I would like to submit our prayers. We respectfully seek a declaration that limited access to technology under-resourced schools violates the learner's right to Section 29, Section 28, subsection 2, Section 9, and Section 10 of the Constitution. We seek an order for the Department of Basic Education and the Provincial Department of Education to provide equitable technological infrastructure at Uhuru immediately, and a structural detailed plan within 90 days on implementing technological infrastructure to ensure equitable education, with regular updates to this constitutional court. We pray that the court directs all costs of this case to the respondents in Scale A and in terms of the BioWatch principle. The court should also include the costs of 4 councils. Now, if the bench has no further questions, or no questions at all, your justices, I would like to take my seat.
Good day, Council. You say there's discrimination based on poverty and that unequal resources. All we know from the school that has got access to the library and the technology is that it's a public school. Do we assume that it's in a more affluent area, or on what basis do you make out the case that it's based, or that the discrimination is based on poverty or on social economic grounds?
May you please kindly rephrase your question, your justices?
As I understand your argument, your case has been that there's been discrimination at Uhuru School because you haven't been given equitable access to technology. And your case has been made out that the Department of Education or the respondents are treating you unequally because on the basis of social economic grounds and or poverty. But from the facts before us, we do not see that the school that has access to this is an affluent school, or that it is not situated similarly on social economic circumstances as Uhuru School. So do we make that assumption, or how do we see that it is not similarly placed socially, economically, or that it is better or more affluent from the facts before us?
As it pleases the court, your justices, we submit Section 7 of the subsection 2 of the Constitution, which states that the state must promote, protect, and fulfill the rights in the Bill of Rights. The failure of the Department of Basic Education to provide technology at Uhuru High School violates Section 7, subsection 2 of the Constitution, exposing the learners at Uhuru High School to be exposed to unfair discrimination. Your justices, we submit that even though it is stated in the facts that where schools have access to technology, this is paid for from the funds raised by the individual schools. In this case, your justices, as the counsels for the applicants, we humbly submit to this honorable court that it is not about who provided the technological resources. It is about the obligation that the Department of Basic Education has to provide the technological resources at Uhuru High School. If it pleases the court, your justices.
Thank you, Advocate Sese, for those very remarkable submissions that you have made. However, I would like to ask a question. In your prayers, you indicated that you are asking that the department rectifies the situation within 90 days. Should perhaps the department not be given a bit longer?
Your justices, we submit that within 90 days, the Department of Basic Education should start implementing a plan on addressing the lack of access to technology at Uhuru High School. Your justices, we also submit that the Department of Basic Education is obligated in the South African Schools Act, Section 58C, that it must comply with the norms and standards contemplated in Section 5A of the Constitution. If it pleases the court, your justices.
Yes, Ms. Sese,
Yes, Your Justices.
Your case is that the discrimination is committed by the Department of Education in not providing similar facilities for the educators at these different schools. But looking at the facts of this matter, the Department of Education mentions that it is not the department that provided these facilities, but these facilities have been paid for from the funds raised by that individual school. In other words, that the facilities, the presence of facilities has, the department did not provide the facilities, but that school raised funds to have such facilities. Can we say that under such circumstances that the Department of Education discriminated against Uhuru High School?
Your Justices, we submit Section 58C, the compliance with the norms and standards of the South African Schools Act. Subsection 1, it states that the Department of Basic Education must comply with the norms and standards contemplated in subsection 5A. Section 5A provides for laboratories for science, technology, and life sciences in public schools. Therefore, Your Justices, Section 58C obligates the Department of Basic Education to comply and provide those technological resources at Uhuru High School. We further submit the Section 7, subsection 2 of the South African Constitution, Your Justices, which states that the state must protect, promote, and fulfill the rights in the Bill of Rights. The failure by the Department of Basic Education to provide technological resources at Uhuru High School is not upholding, promoting, and fulfilling the learner's right to basic education as enshrined in Section 29 of the Constitution.
Yes, but the problem is prayer number 2 of your case, that the unequal access, implying that the department provides unequal access.
Your Justices, we submit that the learners at Uhuru High School are not able to access the technological resources that the learners at Alpha High School are able to access. We submit Section 9, subsection 2 of the Constitution, which states that equality includes the full and equal enjoyment of all rights and freedoms. The failure of the Department of Basic Education to provide the technological resources at Uhuru High School makes the learners at Uhuru High School to be now unable to fully and equally enjoy their right to basic education compared to the learners at Alpha High School. Hence the unequal access to technological resources, Your Justices.
Ms. Sese, isn't your case that the department isn't providing resources to both schools? It's just situational that Alpha School has parents and other means to provide access. But it's a fundamental failure on the part of the department to provide basic facilities to all the schools. And it just happens that you have a comparator between an area where the parent body are able to supplement the deficit on the part of the department as against an area where they aren't able to do so. So your case is that there's a failure on the part of the department across the board, but the prejudice to the learners arises in consequence of whether or not their parents have the means to make up for the shortfall on the part of the department.
Your Justices, we submit that learners at Uhuru High School must be able to access technology as per Section 5A of the South African Schools Act. Now, the Department of Basic Education is obligated to provide technological resources to all public schools, Your Justices. If Alpha High School is able to afford those technological resources for themselves, that's fine. But the Department of Basic Education is still obligated to provide those technological schools to all public schools, even those who do not afford to have those technological resources by themselves.
Thank you very much.
it pleases the Court of Justices.
Anybody for the respondent? You will also have your 5 minutes protected time. And your 5 minutes starts now.
Good day, Justices. My name is Surprise Magula, and my co-counsel is Letabu Moeng. We are representing the respondent, Department of Basic Education and Provincial Department of Basic Education. I will use 10 minutes to address issue number 1, and my co-counsel will use another 10 minutes to address the second issue. As it pleases the court, may I address the court? Justices, I would like to take 1 minute of this court's time to address my rebuttals. Justices, first, the applicant asserts that they have not been provided with quality of basic education. They stated that the applicant, Azania Mazibuko, went to a science welfare, but not at Alpha High School. I say, she has not been in Alpha High School, hence she is not aware, rather she's not of knowledge, that the other facilities, like the technological facilities at Alpha High School, have been provided by the department. I say again, as the counsel of the respondent, as Ms. Azania Mazibuko is a grade 11 learner, and her right to basic education has expired while she was doing grade 9. We must take note that hence she is now in FET phase and she is in grade 11. It was of the opinion of the judges. Then we say again, the case court, we cannot supersede the Constitution, which is the supreme law of the country, that the right to education extends to grade 9 only. As it pleases the court, Justices, in issue 1, we will assist this court in answering the following question. Whether the lack of access to technology at Uhuru High School violates the learner's rights to education in Section 29 of the Constitution or not. We submit that the lack of access to technology at Uhuru High School does not violate the learner's right to education in Section 29 of the Constitution. And further argue that the right to basic education extends to up until to grade 9. In our line of argument, we will highlight Section 36 as a limitation clause and further give clear interpretations that the applicant's rights to education, equality, and freedoms have not been violated and are protected as accorded by the Bebuda Act and other legislations like regulations related to minimum uniform norms and standards for public school infrastructure. Thereafter, we will highlight the case laws related to the case in hand for consideration and subsequently move to analysis and price of relief. Justices, the lack of access to technology at Uhuru High School does not violate the learner's right to education. Section 29 of the Constitution and the right to basic education extends to grade 9 only. The applicants, Azania Mazibuko and Education for All, argue that the lack of access to technology, science laboratories, and limited library at Uhuru High School represents a form of violation to the right to education under Section 29 of the Constitution. Section 36 of the Constitution deals with limitations of rights. It provides that the rights in the Bills of Rights may be limited in terms of in certain circumstances. It states that the rights in the Bills of Rights may be limited in terms of the general application, to extend that the limitation is reasonable and justifiable in an open democratic society based on human dignity, freedoms, and education. We submit that if the court finds that the respondent has limited the right to education, then the limitation is reasonable and justifiable under Section 36, subsection 1 of the Constitution. As we consider that many other schools still have so much less than Uhuru High School. In the matter between Equal Education and another versus Minister of Basic Education, the minister also did not deny the backlog in basic school infrastructure. The minister readily acknowledged that significant numbers of schools still lack most basic resources: water, sanitation, and electricity. The large numbers of schools still face serious problems with class size, quality of educators, and availability of learning material. She posited through that there has been significant improvements. We rely on this case, hence the minister did not deny the backlog in basic school infrastructure, and further stated that there is a great improvement Justices, by December 2030, we believe all should be attained. In the Mogo matter versus acting principle of Melusi, justices made a notable statement that we also rely on as the counsel of the respondent by stating section 29 subsection 1 of the Constitution, which distinguishes between basic education and further education. The right to the former is immediately realizable. The National Qualification Framework of the South African Qualification Authority defines basic education as...
Mr. Mbakula,
Yes, sir.
now you can be interrupted. Please proceed.
All right. As it pleases the court, I'd like to proceed. Covering grade 9, grade R to grade 9. Let us not lose the fact that the applicant is in FET phase 2 in grade 11. So she has received the basic education.
Counsel?
So,
Counsel, just before you, there's one area that you touched on that I need you to understand you. Are you suggesting to this court that the fact that Azania is beyond grade 9 and therefore beyond the threshold of basic education, she has no cause to complain? Did I understand you to be advancing that argument? What are you saying? Because the impression that I got is to say she's just complaining, but she ought not to be before this court because she's beyond grade 9, she's beyond basic education.
as it pleases the court, may your justice please rephrase the question?
I'm saying earlier on when you, and that's why I seek clarity, because I have to be fair to you to understand your arguments in full. You made a comment which to me suggested that you are saying to us, Azania has passed grade 9, which if I understood how your proposition goes, is that grade 9 is where basic education ends. And therefore you are suggesting that because she is above that, she is at grade 11, she can't come before this court and raise issues that relates to grade 9s because she is not one of them. Did I understand that argument correctly? Because if that is not your argument, this is the opportunity for you to clarify for me what you are actually saying.
All right. Thank you, Justice Tulare, for your question. Okay. The department could argue that a provision of access falls within the realm of socio-economic rights, which are subject to progressive realization under the South African Constitution, Section 29. They may assent that while the right to basic education is immediate, the inclusion of technology and digital resources fall within the scope of broader socio-economic improvements, which resources may fall within the scope of socio-economic improvements, which of our own contingent and available resources. And it is stated in the South African Qualification Authority. Now, as it pleases the court, may I proceed?
Miss,
I'll live with your answer, thank you.
Mr. Bakula, just a follow-up on that question.
Yes.
The case of Amoko, which you referred to,
yes,
when in making another argument, my understanding, tell me if I don't understand it correctly, in particular paragraph 32 of that case, is to the effect that to limit basic education under section 29(1)(a), either to only primary school education or grade 9 or the age of 15, was found to be unduly narrow interpretation.
May you please rephrase the question?
The question is, if you look at the case of Moko, the law has been laid that you cannot limit the basic education or primary school education up until grade 9. So what do you say to counter that, what has been decided in the case of Moko?
What has been presided in the case of Mogo is that they stated that section 29 subsection 1 of the Constitution, it distinguishes between basic education and further education. And now the applicant, Azania Masibugo, she's now falling under the further education, which is the FET. As it pleases the court, may I address the court?
That's fine.
Sorry, Advocate, if I may. If I may just before we move on, I just need some clarity on an issue, and it actually arises from what my brother Tulari was asking. It's two things. As I understood your address in the beginning, there were two things you said. The one thing you said was that her right had expired, and I'd accepted that submission on the basis it had to do with her age. And for a minute, if we accept that it is her age, am I correct, first of all, in that assumption?
Yes, you're correct.
So that's correct. So it's her age. In other words, she's now going to be, she's 17 and she will be 18. If that is so, and you made the next submission, was that at basic education is up and until, did you say grade 9?
Yes, grade 9.
All right. Now what happens to a student who's over the age of 18 and is still in grade 9? That is the first thing. And the second thing is, how is the argument then disturbed on the basis and the reliance of the best interest right, which your learned colleague raised, when a child then becomes, that ceases and they become 18, and no longer the best interest right, is how does that all fit into these two submissions which you try to then pack in the introduction recordal of your argument?
Thank you, Justice Rati, for your question. So if there is any person that is over the age of 15 years and still in grade 9, they will receive the basic education up until to an extent that they move to the next grade, which falls under FET phase from grade 10. Then only then the limitation can be applicable. So as it please the court, may I continue? Section 29 of the Constitution contains the right, subsection 1A, the right to basic education, and the right to adult education, subsection 1B. With the further education, which state through reasonable measures must make progressively available and accessible. It has to be recorded that other most former Model C schools that have additional resources other than those provided by the Department of Basic Education, due to their fundraising and or inherited from the injustices of the past. The state is therefore obligated to ensure that all learners receive basic education irrespective of their social origin and other grounds listed in the Constitution. The right to education does not include the right to access to technology. As Article 1 of the World Declaration Act ensures access to essential learning tools and content that one requires for fundamental skills and are directly available.
Mr. Makula, you make the point that access to education doesn't include access to technology. Now, in the world we live in today, technology is at the center of everything, at every single facet of our lives. What value does basic education have if it doesn't perforce include access to technology and education around technology? Because then it's no education at all. So surely what is considered to be basic education must be understood to include the basic tools that are needed for a learner, assuming they leave school in grade 9, that they're able to go out and make their way in the world. How can technology be divorced from that?
Thank you, Justice Miller, for your question. We do not deny that technology is important in education, but we stick consistently to the fact that the basic education has been provided to the applicant. Hence, the right to access to technology is being limited throughout our financial constraints. We're still on budget cuts.
Yes, but the basic education provided to the applicant has empowered her to understand that what has been provided is incomplete. That's why this application is before us today, because she's been educated to a point to understand that it's not enough. It requires more. It requires access to the technology. Now, on what basis does the department draw this artificial distinction and say, well, at grade 9, up to grade 9, we're not going to provide access to technology? Possibly for further education and training, we'll do it. But up to this point, we won't do it. How is that reconcilable with a right that has meaning?
May the Justice please repeat the question?
if an arbitrary line is drawn in the sand to say up to grade 9, you don't have access, we've got no obligation to provide access to technology. It may be that we'll provide it later as you made the submission under further education and training.
Yes.
But if grade 9 is the basic level and it doesn't take the person with that education into the world, assuming the education ended there, then what value does that basic education have? Surely it must have access to technology as one of its key components. In this case, the applicant understands that. That's why the application's been brought. So how does the department draw that line in the sand between grade 9 and what happens after grade 9?
Thank you, Justices. They will still be able to use the municipal computers. Hence, this is a progress of the Department of Basic Education. And they can also get the access to use municipality computers. As it pleases the court, may I continue?
Council, just before you move on that, is access to technology not a resource to realize access to education?
Thank you.
Is it not a resource to realize access to education?
Thank you for your question. Yes, we agree that it is a source, but due to the budgetary constraints, the department may cite budgetary constraints as a significant challenge, arguing that it has limited resources and has prioritized immediate and urgent educational needs such as classrooms, textbooks, teachers, and salaries and basic infrastructure such as sanitations and water and electricity. Given South African financial constraint, it is necessary to prioritize essential physical.
Perhaps you can deal with this dilemma by just indicating on what basis do you limit access to basic education to mean that it is up to grade 9? What is the basis for this argument that it is limited up to grade 9?
It is limited in the basis of Section 29 of the Constitution. Subsection. Okay. As it pleases the court, allow me to continue.
Please proceed, Mr. Makul, and please round up. Your time is almost up.
Let's see. Section 28 of the Constitution, in the best interest of the child, provides that the child's best interests are of paramount importance in every matter concerning the child. The best interest of learners in the case in hand is that both learners have been provided with basic education. As not having technology does not affect basic education, and it is not in the best interest of learners who have less than Uhuru High School, such as some have still pit toilets. And we are ensuring that those should be accomplished before we can comply with the demands of the applicant. Justices, the respondents are well aware of the regulations related to minimum uniform norms and standards for public school contained in these regulations. All regulations must be planned and prioritized and phased in before 31st December of 2030. Justices, we are not yet in 2020 but still in 2024. Minister Sifuyo Kharube indicated a budget cut recently this week on the 25th of September 2024. Also in the Western Cape Forum, Intellectual Disability versus Government of South Africa, the court recognized that the provision of basic resources depends on availability of resources and circumstances. Uhuru High School receives more than Alpha High School due to the quintile system which aims to heal the division of the past. In the matter between Mazods and others versus Minister of Basic Education, the justices held in the first instance of the nature of rights that requires the writer take all reasonable measures to realize the right to basic education with immediate effect. This requires that all reasonable measures to realize the right to basic education with immediate effect. This requires all necessary conditions for the applicant that the basic necessary conditions for the achievement to the right to education have been provided by the respondent. The state take all reasonable measures to ensure that all learners have access to a basic education with immediate effect. The right to education is immediately realizable but not absolute and may be limited. Justices, adhering to the applicant's demands could violate other fundamental rights. The right to basic education cannot be viewed in isolation, as its violation could affect multiple of other rights. This requires the provision that all necessary conditions for the achievement of the right to basic education Justices, we request this court to affirm to the applicant that the basic necessary conditions for the achievement of the right to education has been provided by the respondent. If it pleases the court, I shall now hand over to my co-counsel to address issue number 2.
Thank you, Mr. Makulu.
Greetings to the esteemed members of the court. As introduced by my co-counsel, my name is Letabo Moreng, and I've allocated myself 10 minutes of this court's time. My justices, I will be making 3 submissions in continuation of the respondent's defense against the applicant in this case. Through my submissions, I will be highlighting the errors in the submissions made by the applicants. To outline for the second issue that I'll be dealing with, it will assist this court in answering the following question. The question before this honorable court is whether or not the unequal access to technology between public schools violates the learners' rights to equality and protection from unfair discrimination as provided for in Section 9 of the Constitution. To outline my case, I will firstly prove that the DBE and DOE are not in violation of Section 9 of the Constitution. Secondly, I will be dealing extensively with the limitations placed upon the learners' rights to equality and why we believe this limitation is reasonable and justifiable. And lastly, I will prove that the respondents are not in violation of Section 28, subsection 2, and that we do in fact have the best interests of the children involved at heart. If it pleases the court, I will now begin with my first submission, which will deal with Section 9 of the Constitution. The counsel for this applicant submitted that the respondents violate Section 9 of the Constitution. We submit that Section 9 contains 3 important sections. First, a right to equality before the law and equal protection and benefit of the law. Second, permission for the state to take positive measures to advance and protect groups that have been disadvantaged by unfair discrimination. And third, a prohibition on unfair discrimination by the state. The counsel for the respondent submits Section 9, subsection 1, which deals with equality. Equality is not a single idea. There are many types of equality. When we talk about equality in education, there are 3 valuable forms of equality that we have in mind. First, equality requires the equal enjoyment and protection of constitutional rights. We submit that the learners at Alpha High School and Uhuru High School receive the same basic education as defined and proven by my co-counsel. Second, equality is about accommodating and valuing difference rather than promoting uniformity or treating everyone identically. The quintile system ensures that learners from disadvantaged backgrounds receive a bigger financial allocation than learners from advantaged areas. Finally, equality requires us to break down patterns of group disadvantage and to prevent new patterns of disadvantage from forming. The counsel for the respondent submits that when the learners at Uhuru High School attended the science fair, there was no stigma, stereotyping, or socioeconomic disadvantage evident. Therefore, the counsel for the respondent concludes our submission on equality by stating that this state should find that the respondents treat both schools equally and are not violating Section 9, subsection 1 of the Constitution. Our second submission is that the respondent has not violated Section 9, subsection 3 of the Constitution. The counsel for the applicant submitted that the respondents unfairly discriminated against the applicants. We submit that in everyday language, we use the word discrimination to mean a very serious type of wrong. In South African law, we use the word in a slightly different way. Discrimination is not wrongful in itself. It is only wrong if it is proven to be unfair. The counsel for the applicants failed in their attempt to prove that the respondents unfairly discriminated against the applicants. We submit Section 1 of the Equality Act, which defines discrimination as any act or omission that imposes disadvantage or withholds benefits, opportunities, or advantages from any person on one or more of the prohibited grounds. In the case of Hodgson v. Lane, the Constitutional Court defined discrimination under Section 9, subsection 3 in slightly different terms. They defined it as differentiation that is directly or indirectly based on the prohibited grounds. From the above submission, it is clear that the respondents never imposed any type of differentiation on Uhuru High School. The respondents submit that they've always treated the schools the same, and in some circumstances, Uhuru receives more than Alpha High School. We submit that access to technology is not one of the grounds for discrimination, and therefore it is unfair to state that the Department of Basic Education has discriminated against the applicants. We further submit that some forms of discrimination in schools are fair. Section 14, subsection 3 of the Equality Act sets out factors to consider when deciding whether or not discrimination is unfair. This is called the test for unfair discrimination, and in it we must determine the impact and justification of the discrimination. We submit that the impact is not severe. Not having access to technology at school does not impact the rights of the learners to a basic education as proven by my co-counsel. Therefore, we submit that it is justified that some schools do not have Wi-Fi and laptops for all the learners, as there are more pressing needs that need to be fulfilled first, such as 14% of schools not having access to proper toilets, and another 25% having an unreliable water supply. We submit that in the case of Hawks Inverse Lane, the Constitutional Court concluded that if the results of the test show that the differentiation or treatment has a valid purpose, then it can be considered as fair discrimination. And while it is sad that some schools have less resources than others, it does not amount to unfair discrimination unless the applicant can prove that such differentiation results in harming the learners. And unfortunately, the counsel for the applicant failed in the attempt to prove the harm caused by the applicants. In the case of Minister of Education versus Harris, the court stated that the state has a duty to ensure reasonable measures to achieve the right to a basic education, but it is not required to provide the same resources to all schools, and that the allocation of resources is based on factors such as student population, school location, and the existing infrastructure. We submit that the clear conclusion is that the lack of access to technology does not constitute as unfair discrimination, as socioeconomic status and poverty are not listed grounds in Section 9 of the Constitution. We will conclude our second submission by stating that this court must find that the actions of respondents are constitutional, as it does not unfairly discriminate against the applicants. This brings me to our third submission, which is that the limitation placed on the learner's right to equality is reasonable and justifiable in terms of Section 36 of the Constitution. The limitation does not fully deny the right to a basic education to the learners at Uhuru High School. Rather, it just restricts access to certain technological advancement resources, as learners still receive a basic education through textbooks, classrooms, and teachers. We submit that the limitation is therefore not absolute, but rather a way for the equal distribution of resources. That we submit that the state has other difficult choices to make in deciding how to best allocate its time. And in conclusion, the limitation placed on the learners at Uhuru High School regarding the access to technology is justified under Section 36 of the Constitution. Tripartite Steering Committee versus Minister of Basic Education, or Section 27 versus Minister of Basic Education. I can go on and on, but what both these cases have in common is that there is a backlog in providing basic school infrastructure. And as much as the respondents have proven that has been significant improvement, we submit that it is in the best interest of all children, as stated in Section 9 of the Children's Act and Section 28, subsection 2 of the Constitution, that we prioritize a basic education before we can focus on the access to technology. Technology is important, but not as urgent as other needs, as other resources that are necessary. It has always been the priority of the respondents to treat all citizens of our country with dignity and fairness, and we submit that the respondents are not in violation of Section 10 of the Constitution, as the applicants might try to prove. We submit that the respondents fully apply the findings in the case between Mazoso versus Minister of Basic Education, which stress that the state must take all reasonable measures to realize the right to a basic education with immediate effect. We submit that the respondents ensure that all necessary conditions required for the achievement of the right to education are to be provided. In conclusion, while we acknowledge that technology has become a tool that can be used for additional information, we must emphasize the importance of safety in schools above all else. And the Council for the Respondents submits that we respect and uphold the constitutional rights to equality, education, and the best interest of children. Let us uphold justice by relying on reason, evidence, and the principles of fairness. The claims of constitutional violations and unfair discrimination do not hold under scrutiny, and that is why we believe that we have proven their invalidity. As the respondent, we are dedicated to fulfilling our Constitution's obligations and improving educational facilities within the constraints we face. The progress the DBE has made is a testament of their commitment, and to accuse them of negligence is to overlook the complexities and efforts involved. We therefore submit the following prayers on behalf of the respondent. First, we ask that this court should find that the lack of access to technology does not violate the right to a basic education in Section 29 of the Constitution. Second, we ask that this court must also conclude that the lack of access to technology does not constitute as unfair discrimination because socioeconomic status and poverty are not listed grounds in Section 9, subsection 3 of the Constitution. And lastly, we ask to be compensated for all the funds that were used throughout the duration of this case. And unless there are any questions, I shall now take my leave.
Ms. Moraine.
Yes, Your Justice.
I need to talk to you about two cases. The Huxon differentiation principle, as well as the Harris one. The Harris one speaks about the locality of the need. vis-a-vis what you have contended to be the respondent's case, that you cannot be expected to provide everything. You have to prioritize what is of immediate need at that time. Do I understand your case to be that your budgets or your resources could be adequately used in socio-economic rights such as access to water, toilets, and everything, over and above the technology that is being asserted by the school where Azania is?
Thank you for your question, Justice. We submit that, yes, it is important that we prioritize safety in schools and ensuring that learners are able to receive a basic education in a safe environment that protects their constitutional rights.
But if Azania school says the problems about water, the problems about toilets, those are not our problems. Our problems are one of technology. We want technology, the libraries and everything else. Why should you want to treat them like all other schools? Harris, the judgment in Harris does not allow you to do that. It says you must approach it based on the locality of the problem. So I just want you to deal.
Your Justice, we submit that when we talk about section 28 subsection 2, it talks about all children and not just a specific group of children that we need to prioritize. And deprioritizing safety in schools means, and reallocating the resources that we have available to technology would mean that we would not have the necessary amount of resources to make sure that other schools also have safe environments to learn.
Remember, the fact that it rains in Limpopo doesn't mean it's raining here. If Azania school, they require technology, and the Limpopo school requires toilets to replace those pit toilets, it is their problem there. But the problem of Azania school is we want the technology. We think if we're not getting the technology, we have been discriminated against. Is that a good case for them?
Thank you for your question, Your Justice. We submit that the learners at Uhuru High School are able to receive their basic education through their textbooks and their classrooms and their teachers that are available at the school. And technology should be something that we make progressively available, as it is something that most of the learners from grade 10 to 12 require.
Council, looking at the regulations relating to the minimum uniform norms and standards for public infrastructure, school infrastructure. Paragraph 16 thereof refers to all schools must have some form of wired or wireless connectivity and for the purposes of communication, which must be maintained and in good working order. Do you realize that this requirement is couched in peremptory terms?
Thank you for your question. We submit that we do accept that we have not made electronic connectivity available at this school. However, we need to understand that the COVID-19 pandemic caused the urgent reallocation of resources, which did not help us in making sure that we abided by the norms and standards. We could not predict that a COVID-19 pandemic would happen, and therefore we were not able to abide by the norms and standards because of the other urgent allocation of resources that we had to make available. Unless I am no further use to the court.
Like there is any question?
Yes, I shall now. Thank you for your question,
Okay.
to justices.
Thank
I will now take my leave.
Yeah. The applicants, you now have an opportunity for a rebuttal.
As it pleases the court, once again, Your Justices. Your Justices, our learned friends over here submitted that limiting the right to basic education is reasonable and justifiable. Your Justices, we submit that the limitation of the right to basic education is unreasonable and unjustifiable due to the fact that technology is at the center of education. Why do we submit this? Your Justices, it was stated in the facts, paragraph 1, line 7, that the learners at Uhuru High School are given projects and assignments. In order to be able to do their project and assignments, Your Justices, the learners at Uhuru High School must have access to technology as enshrined in Section 5A of the South African Schools Act, subsection 2, Roman figure 6. Your Justices, our learned opponents over here also submitted that technology is not necessary. They have provided the basic resources at Alpha High School. Your Justices, we submit that not equipping learners at Uhuru High School with the necessary technological resources that they will need hinders the learners' ability to even compete in the workforce and in the future, as there will be cases where the learners are required to be having the technological skills in the workforce. Our learned friends also submitted that they have up until 31 December to provide technology to all public schools. Your Justices, we submit that the Department of Basic Education had 28 years to address the past inequality in access to technology due to the apartheid system. They have failed so far, saying that they will now provide the technological resources within 6 years, Your Justices. It is totally impossible. Our learned friends also submitted that there are schools with pit toilets. Your Justices, this further submits and proves that the Department of Basic Education is indeed failing to avail Section 29 to all public schools. Your Justices, for how long must we wait for the Department of Basic Education to list all their failures instead of actually implementing a plan that addresses the past inequalities of our land? They also complained on tight budgets. Your Justices, we submit that this constitutional court in the case of the Juma Masjid held that the right to basic education is immediately realizable regardless of the available resources that the state has. The Department of Basic Education should have just opted for financial aid, but they chose to be ignorant. It is hence that we as the counsels for the applicant submit that the failure of the Department of Basic Education to provide technology at Uhuru High School is indeed in violation of their right to basic education. If it pleases the Court, Your Justices, I would like to take my seat.
Sorry, before you resume your seat, we haven't heard you on the submission that was made that basic education ends at grade 9.
Your Justices, we submit the CAPS document which was released by the Department of Basic Education. In the CAPS document, Your Justices, basic education starts from grade R to grade 12, which proves that the learners at Uhuru High School still fall under basic education. If there are no further questions, Your Justices.
Anna, sit down. Thank you.
As it pleases the Court, Your Justices.
Closing argument for the applicants. Address. No one has it. Oh, okay. All right. Court will adjourn for deliberations.
Yeah, just.
Good afternoon. We have now come to the end of the presentation. Before I start, I must make the disclaimer. I'm not the Chief Justice. I'm the Chief Justice for the day only. Yeah, the Chief Justice is Justice Mandisa Maya, my colleague. So I'm neither the deputy, but for the day, for the purpose of this Moot Court, I'm the Chief Justice, the presiding officer. Thank you very much for your well thought out, well prepared, well researched presentation. We deliberated a lot with my colleagues about which of the team made a proper or a compelling presentation. We are unanimous with the fact that all of you made good presentation. It actually informs us that you were fully prepared for this. And for that, you must give yourself a pat on the back. And those of you who intend following the career of law, the future is now more brighter than ever before. And having presented argument before 14 judges is no mean feat, and fielding many questions and answering all those questions clearly indicated to us that you can think on your feet. You do have advocacy in you. We were, all of us, all impressed by your presentation. You were not intimidated, and even the way you addressed the court is heartwarming. The applicant asked for costs for 4 counsel, and the answer is not hard to find, because you are all preparing for the same case. You could not exclude the others. Even those who could not participate, you were there as part of the team. And we understand that only 2 or 3 could participate. Don't feel bad. Your turn will come, perhaps in the real world. You can ask that all these justices here, they should adopt you and be your mentors. I've adopted a lot of students, and if you want me to adopt you, I'll adopt you. It's an easy way for you. If you have somebody that is mentoring you, then you can see your way through very easily. Make use of this opportunity. It doesn't come more often, and you may not even have it. We can parent you, all of us. We can make sure that whatever dream that you want to achieve, you realize it. It's a right. We're giving you that right. A right to basic education. And it is not limited to grade 12. Even when you are going to universities and or tertiary education, if you still need our help, you will get our numbers, and then we can always help you. I don't mean only you who have participated. I mean the entire group that was part of this session. It would give us pleasure to see you appearing before us very soon. The bench, as you can see, it's young, and they're all waiting for you. I still have many years on this bench, so you will find me when you are ready. So, and the bench also on my left, they're young. They've just been appointed. Some have been appointed 2 or 3 years back. So they're ready to receive you. And they are recent. So everyone who wants any one of the judges to mentor you, please feel free to approach them. They are ready and willing to be mentored by you, to mentor you. Coming to the business of the day. This is the reason why you are here. You are not here for mentoring and whatever. Unfortunately, we have to choose a winner. And unfortunately, we have to choose the best oralist. But that does not mean that the others did not measure up. If it was up to us as a bench, we would have chosen all of you as the best and all of you as the best oralist. But because of the rules of this competition, we are asked to choose one team, we are asked to choose one oralist. So we will do that, and we have done that. When you consider this case, you could look at it and say it was easy and heavily burdened towards the respondent. Because as far as the applicant is concerned, the critical point was the obligation the state has on the right to education. Those who have acquainted themselves with the judgment of this court in Mogo would have realized that the right to basic education does not end at grade 9, but goes further. In Mogo, I was part of the bench. Mogo, who was a grade 12, just matric, was prohibited from writing the examinations, and he missed the final exams. And he approached this court, and I remember we sat in December, and what was critical was the right to basic education. Where does that right start and where does that right ends? In a judgment penned by former Justice Kampepe, he extended it beyond grade 9. Mr. Makula, when you were asked about whether the right to basic education starts at grade 1 to grade 9, and I know you read the judgment and you could not concede to say it extends, because had you considered, that probably would have been the end of the respondent's case. So I understand why there was a reluctance or a reticence on your part not to concede and argue other points, which you argued very well. And your fellow co-respondent counsel supplemented you very well. So we were really, really impressed, because what most impressed us is you divided the responsibilities. One of you argued a certain point, the others supplemented it. So your argument, the argument that you gave us, was full and sound. That is why we deliberated a lot. We took some time to come at the right decision. But we are unanimous with one thing, that the preps, the presentation, the arguments, and how you were able to deal with questions was perfect. We can't find any blemish on your argument. It clearly shows that there's a lot of preparation that went in with this case. So the final chapter is the best team, according to the scores and the deliberations by my colleagues and myself, is the applicant's team. And as far as the best oralist, there was a lot of debate around who is the best oralist for the day. The debate was between Mrs. Murweng and Mrs. Masango. Miss Masangu, sorry. I'm sorry, my apologies. Miss Masangu. The unanimous decision is Miss Masango, you were the first, and then you get the accolade of being the best oralist. My colleague that I sit with on the bench would want to say something to all of you.
I really want to congratulate all of you. You were excellent. And I wish you were the council that appear before us. If you're this good at this age, the sky is the limit. And I always, and forgive me, gentlemen, I'm always so proud that women has come this far. And I see a bright future for all of you. And it's a great honor to serve this country, and in your ways, I hope all of you will serve this country one way or the other, so that we can build the South Africa we all love, and where everyone will get everything that he or she may need to be the best person in their existence here on earth. So congratulations to all of you. You are all great. Remember that. And also you who are sitting at the back. I'm looking forward to the future because I see you so much wiser and more feisty than I ever was at that age.
Oh. Wait.
Good afternoon to all of you. Well, I share the same sentiments with my colleagues. You are, wow. In your language, you are wowza. All of you. I am the beneficiary of the Moot court competition myself. In 1998, I was representing the then University of Transkei in all Africa Moot court competition in the University of there in Mozambique. So you started early. From high school, I mean, I could not have been this good. I mean, you are perfect. If it was in the days of the old, when you did not need to go and do LLB, you would just do articles, I would have given you the robes already to say, serve articles. You are just so excellent, and your articulation and understanding of the facts, the issues, and the law, it's marvelous. It is good, and we look forward to seeing you appearing before us, for those that are considering to be legal practitioners. You are, I mean, I'm blown out. I'm really so impressed by all of you. You did well.
Good afternoon, everybody. I share in the sentiments that have been expressed by my colleagues. What I want to emphasize is, even if now you didn't think of going the legal route, you have seen what you are cut out for. My take here is that you should really seriously consider coming aboard, doing law. You've just shown many that it is doable.
there's always been this saying that law is difficult. Yes, it's not an easy subject because you have to decide on the issues of life and death of people. But looking at the caliber of orators today, it is doable. You must have seen it yourself. It is doable. So mine is to encourage you to consider a career in law. You were all best orators, and as for the respondents, really the case was difficult, but you made the best out of a difficult situation. This is what pertains in law. You will have to argue your case, present your matter, regardless of the circumstances, and present your client's case. And this, you did exactly that. Thank you.
Thank you. If I may just say two things. The first thing that I want to say is often people would say to you, and this is what the bench is saying to you, is that it's been a privilege to hear you. Now, what that really means for all of us is that you were able to allow us to turn the cube. In other words, we thought of one thing, but when we deliberated, we thought of something else. So that's the art of what this bench wants you to take. So the privilege is not necessarily always hearing you, but it's the ability of how you articulate and tell us that shows us how to move the cube. So when we deliberate, it means we had our foot in the left side, and suddenly then we were at the right, until we then as a bench found our balance. A tip that I can give for all of you is that when you are trying to articulate yourself, always take home that you need to take your time. I often say the following, and it sounds a little bit inept, but I do. I say, counsel must romance the court, lure me in slowly so that I can understand what you're saying. The second point I want to make is notwithstanding the fact that the applicants walk out here triumphantly, and yes, you do, but we deliberated on the prayers, and we're not entirely sure, as far as the bench is concerned, that this is a matter that we may consider going forward with regards to the second leg, which was discrimination. And so the tip that we want to give you is notwithstanding the fact that you won, but not all the prayers may have been granted. And the simple tip here is that if one is dealing with discrimination, sometimes what is important is to compare apples with apples and not pears with apples. Hence why the bench asked you questions whether the two schools were on the same footing. But be that as it may, that is a mouthful, but it was an absolute privilege from my side. Well done.
Thank you. I am also humbled to have been part of the audience to listen to. There are just a few things that I wanted to share with you going forward, and also thanking those who prepared you. Just bear in mind that when you prepare as a lawyer or as a judge, unfortunately you don't sleep the same day you woke up, all right? But you have a minimal time within which to present your oral argument when you're counsel. So there are a few factors in that presentation that I want to share with you, and one has been touched on by my sister. The first is your voice projection. Just make sure that you are audible. I mean, we struggle to even have the names of some of you. It's an area that you want to, audibility. The speed, something that my sister touched on. The pace at which you take us. And at the very beginning or in the early stages, just set out your proposition. What is it? What is your end goal? So that as you take us through your analysis of what you want to build up, we are with you on the path of travel that you want us to walk with in your argument. And the second last, when you are asked questions, listen to the questions carefully and don't just revert back to your script, but answer what is being asked. Because there are two reasons ordinarily why a judge would ask a question. The first is when your point is not clear. The judge seems to understand you, but there is a risk that you are being understood differently from what you intend to convey. That's when a judge would ask a question. Sometimes a question would be asked because there is a factor that's in the mind of the judge you should be touching on and you're not touching on. So it's kind of to elucidate the issue. And lastly, own the space. It is your time, all right? Own the moment. Put up your best punch. Thank you.
Thank you so much. Mine is simply to congratulate you. You made the best presentation, all of you. Maybe I should also inform you, as we were deliberating, I also got a call from someone who must have been watching stream live from the province of Mpumalanga, one of my colleagues, saying she was marveling, surprised at how much confidence you had. It was as if you are already admitted as legal practitioners. And come to think of it, we are talking of high school learners. I can tell you, I have seen tomorrow. I have seen the future of our noble career in your good hands. I can talk like I've been to Mount Sinai to say I've seen the promised land. You did very well, and maybe it will sound as if I'm a bit selfish if I say I wish all of you will venture, of course, into legal career and come to practice in Mpumalanga when the time is due. It's one of the best provinces to be. We are very proud. I'm not going to say much about further guidance. I think you have been guided further by my colleagues. And the other reason is that by the time you really have to be in the courtroom, you may have forgotten much of what I may have to say now on what to do and what not to do. So you just did very well. If it was upon us, like my brother indicated, all of you would be the winners. And I want to reiterate what he said. We are available to mentor you going forward. We are also the product of mentoring by other judges, so we are willing to give back in that fashion. Well done.
I just want to underscore everything that my learned colleagues have said. You were all exceptional. We have to decide a winner, but you were all winners in the sense that you were all extraordinary. Your confidence, your ability to deal with the facts and the law, to stand up in front of 14 very senior people when you're still learners is exceptional. So please, there are winners and losers as far as the competition is concerned, but you're all winners. You all equipped yourselves extraordinarily in an extremely competitive and difficult situation. So none of you, and I'm sure every learner in the room who's competed in this competition for that matter, should see yourselves as losers. Just come away with an incredible sense of pride and embrace all of the opportunity that being here and being part of this competition has given you. And you're all going to fly, I have absolutely no doubt. Well done, and thank you for the privilege of learning from you. I think we all came away feeling like we learned from you as well, so well done.
Thank you, Chief Justice. I would also like to follow on the lines of my brothers and sisters. The 8 of you are just simply exceptional. You have found your North Star. Stay focused. and be the very best version of yourselves. I always like saying you must see yourself as a brand. And right now I would like to speak to the respondents because I see their fallen faces. You are fighters, especially you, Ms. Moraine. The submissions that you made under difficult circumstances, but you still made us sit up and listen. And in deliberations, it was not easy for us to come to the conclusion. So nobody has lost today. It's just that in litigation, that's how it is. There is somebody who must walk out having, for lack of a better word, won. But it does not take away for the team that didn't receive the nod. Yes, thank you, my sister. That is the wisdom of sitting next to your seniors. Do not be disheartened. As I say, you have found your North Star. Stay focused and be the very best version of yourselves so that you can ultimately get to the goal. And I say this to all of us. This profession is called the noble profession because of the very high moral standards that are expected of each and every one of us. Do not deviate. Do not find yourself doing things that will make it impossible for you to be wearing the green jacket one day. I guess you all know what I'm talking about. Stay focused and remain being the best version of yourselves. And thank you again for the excellence that you allowed us to experience today. Continue that way, and South Africa will be a better country because of all of you. Thank you.
Thank you very much. You've done very well. I'm not going to repeat what my colleagues have already said. To the respondents, before we sat here, or in the benches we sit in, some of us who don't sit here often, or at all, we once represented the parties. It is very heartwarming to hear a client saying, or the losing party, but my lawyer fought a very good fight. But mulao ke mulao. But law is law. So that is the message for the respondents. When your client loses, having seen you fighting, there is nothing wrong with you. Law is law. Thank you very much to the applicant. I also sit here as a beneficiary of the Moot Court competition. Long before you were born, in 1993, I represented University of Transkei, now Walter Sisulu University in Lusaka, Zambia. Also then, it was a flimsy dream that human rights or constitutional court, we didn't even have an idea on how this issue of human rights, democracy and constitution would unfold. Little did I know that 32 years later or 31 years later, I will be addressed by grade 11 learners who are at the par of senior counsel, both of you. In closing, I would like or wish I'm not sure whether it's a protocol, it's just a wish. If it's not a protocol, it's fine, to see the trainers or the teachers. I want to say, both schools, I think it was a difficult task to choose who are going to represent the schools. I am looking beyond the council who stood up today, because their caliber shows or proves to me what other learners or should be. That is, those sitting beyond or behind the lawyers for today. I really want to say, your trainers or your teachers did a good or excellent sterling work that in both schools. Thank you very much, or all the schools. It's not two schools, yes, in selecting what we say today. Hands up to the teachers or trainers.
Just to all of the presenters, the council who presented, I just want to congratulate you on embracing your position as leaders. The proceedings for today has been televised, and in doing so, you take on the responsibility of civic engagement with your fellow learners and the learners out there. And in doing so, you engage on issues on the Constitution, which at the beginning, you read out the preamble. It requires the learners to engage in that. And in doing your presentations today, you engage on the right to equality and the education, and you do so importantly in having students reflect on those issues. And that responsibility as leaders you take forward. So I congratulate you on doing so and to take those positions of leadership forward.
Thank you. We've done our part, and now it's the part for the faculty.
Good afternoon again, all. I am back to take us through the remainder of the program. We will now be continuing with the prize-giving ceremony, but perhaps just from my side, I want to say thank you to Justice Matapo and your panel, Justice, for the very constructive feedback that you have provided and that you have given to our young applicants today. I am sure that they appreciated the challenge as well that you have put before them today, and as you have indicated, they have all performed excellently, and we are looking forward to seeing you all in the near future. And I think from my side, we're also looking forward to seeing some of you in the commission in a few years' time as well. So you all have performed excellently, and we are now going to proceed to issuing you with the prize giving. We have Commissioner Madlingozi, who is going to take us through that process, but for now, I would like to allow the justices to come down so that they will be able to hand over. Commissioner Madlingozi, do you want to take us through the list? Thank you.
Thank you so much. We don't want to stand before you and your right to food. I know people are hungry now. We want to announce further categories. DM, if you can join us, please, Honorable Deputy Minister. The best overall essay is Empangeni High School. The coordinator can come down. Give them the scissors. The best applicant essay, Unitas Secondary School. And then the last essay prize, the best respondent essay, once again, Empangeni High School. Okay. The coordinator for Unitas, if we can come down for the best applicant essay.
Free State.
Free State Province, are they here?
Free State.
No, they're not here. That's a technical person. They're not here. Okay, they're not here. Free State. And then, that's it. Two last prizes. The most improved province goes to the Free State. Unitas. The best coordinated province goes to KwaZulu-Natal. We now call upon the winning team to come up to take the prize. Well done once again. Sikanye Mariani, Milani Sese, Ufenze Masango, Mapula Mabitla. Yes. Just move this way a bit. Just move. Thank you. Finally, the runner-up team, if I can invite you to come up to take your prize. Letabo Moreeng, Utlile Mutlakwana, Sipiwe Mnisi, Surprise Magula. Well done. Last one. The best oralist for the 2024 National Schools Moot Court Program, Offense Masango.
Ma'am Joyce.
Fedi.
Commissioner.
Can I please ask our judges from the panel to please come down so we can award you with our token of appreciation for your participation today. thank you very much, justices and judges. I think you can now return to the bench. If you're done. Okay, they would like you, applicants and respondents, can you please join the judges for a photo shoot? Sure.
Must
agenda properly. Upuhudzana.
Okay, thank you, everyone. Can we please settle down? We are now reaching the conclusion of our program. And I would just like to iterate what Commissioner Madlingozi has said. It is not our intention to stand in between you and your right to food. So we would like to conclude the program for the day. And I would like to call the CEO of the Human Rights Commission, Mr. Vusumuzi Mkhize. He will be giving us the vote of thanks. And as soon as he is done, I just have a few announcements to make, and then we can conclude. Thank you very much.
Program Director, Advocate Pile, the CEO of the Commission, South African Human Rights Commission, the Chief Justice, Matopo, and the justices here present, Deputy Minister of the Department of Justice and Constitutional Development, Commissioners, Commissioner Madlingozi, Commissioner Kwinana, who is doubling up as a justice today, but also the DG from DOJ, the bailiffs who are doing a great job in keeping us in order, to the educators, the principals of schools, and the parents who might be here, to our partners, the Department of Justice, the University of Pretoria, the Center for Human Rights, and the most important young people who are here today, who were representing the applicant and the respondent, and the great job that you have done to make us proud today. Good afternoon. I will not be long because my task is a very simple one, and that is to do what is sometimes very difficult to do by most people, and is to say thank you. Yet it is a powerful message. I think Commissioner Matlingozi made a very clear statement in his opening about grooming and building the future defenders and warriors for human rights. And importantly, the choice of the topic, which is quite relevant in terms of Madiba's quotation, that education is the most powerful engine which can change the world. And therefore the choice could not have been apt for today, particularly when we believe that our country without education is doomed. And the right to education is none but a non-negotiable, and I fully agree with the applicants. Now, I just thought that as we conclude today, I must repeat what has been said about all of us being winners, particularly the learners, from the time they participated at provincial level to this level. When I was asking Mr. Muhaga of the issue of how many learners do we have in the country in basic education, and his answer was clear, 13.4 million. Now, of the 13.4 million, look at yourselves who are here. So when the justices say to you, you are already winners, indeed, out of the 13.4 million, you are the winners who are here today in the Apex Court. So you've done really, really well. Now, there was an article by Yusuf Vauda, who is an associate professor at law in UKZN. One thing that I would like to leave this podium with is a question he posed in 2003 when he spoke about the issue of legal association of the poor. In his article, he asks the question, what is lacking is legal assistance for the poor persons in a variety of civil law, in administrative forums where their rights are routinely overlooked, in governmental bureaucracies which deny them access to social security and other socioeconomic rights, and in the general context of upholding their dignity, equality, and social justice. Then he poses a question: are the poor effectively excluded from the legal system? And that talks to the issue that we had today about access, and the fact that access and improving access to justice will be a task that you as young people will make sure that justice is both accessible, particularly to the most vulnerable. And the question that fortunately I can pose to the justices who are present with us today is, to what extent is access to a justice and to the rights of our people accessible? If we look at 2003 and to date. And secondly, what needs to be done to ensure that access to justice is a relieved reality, particularly for the most vulnerable. And as constitutional judges, we look at you to assist us, for without the human rights, there can be no democracy. So our gratitude then, first and foremost, goes to the justices who have made their time today on a Sunday to ensure that this event is a success and the adjudication process reaches the level of integrity and respect it deserves. We were amazed at the level of involvement and the application of your minds in making a determination of the outcome for today. But we are truly grateful for your support, and we believe that we'll continue with this partnership so that at the end of the day, the access to courts does not remain a dream, but that through this experience, our young people will see that this is not an alien area, but their area too. Secondly, we would like to thank the Deputy Minister and the Minister of the Department of Justice and Constitutional Development and the team who have continued to be support of this particular project that we think is a critical and a pivotal project in ensuring that the access to the courts and the understanding of how the court decorum functions is an important one accessed by all. And thirdly, we would like to thank the legal fraternity, including all advocates, attorneys, and magistrates, legal advisors, and law firms that provided pro bono services in coaching and adjudicating the essays and provincial round phases. The partners acknowledged the contribution by Cliff Decker, Hofmeyer, as well as the SM Patel attorneys for the sponsorship of additional resources and awards that we were able to dispense with today, but also the Study Trust for availing bursary opportunities. All institutions of higher learning, the educators, the parents who might sacrifice everything to make sure their children have access to quality education and participate in this program, whether they are here or not at all levels, we are truly grateful to them. The University of Pretoria, through the Center for Human Rights, for providing technical support and ensuring that the legacy and vision of the program's founder, Professor Christoph Haynes, lives on. The team from the Human Rights Commission, who continued day and night to work with all the partners to make sure that this particular project, which is an important project called the National Schools Moot Court Program, does take place today. We think that we thank you, Team SAHRC, for all the work you did behind the scenes with the colleagues. And finally, to those who are here because of the learners, if you did not choose to focus on this program, and you might have chosen to do all other things that take away from your education, you might have chosen to do anything else except to focus on research and all the skills that you've acquired up to now. But the fact that you had a clarity of mind to understand the value of this program and participate and leave everything else over and above your studies, we think that you have a great mindset about your future, and keep it on and let the burning desire to be the best continue among yourselves. We thank all the learners who are here, but then not the least the program implementers who worked behind the scenes, as well as the media who have been able to make sure that this program is accessed by those who could not be with us here. We thank the media for that work. Thank you very much. On behalf of Commissioner, the Chairperson of the Commission, Baba Chris Nissen, who could not be here today and said, Chief Justice, I must pass his deepest regret for not being here, but his deepest gratitude for yourself and all the justices who are here. We would like to say, as a Human Rights Commission, thank you very much, And may we then continue and meet again in this fashion, even bigger and better in next year. Thank you very much.
Thank you very much, CEO. We have now reached the end of our program. I would like to invite us all to lunch, which would be taking place in the foyer. For our justices and judges, lunch will be taking place at the women's jail. You will be escorted there. Or there is also a finger lunch option for you in the holding room. And having said that, I would now like to close the National Schools Moot Court program for 2024 and end by finally congratulating our participants and wishing you all well. Thank you very much.
Court adjourned.